Welcome to the Deep Dive. We're here to help you break down complex information and really zero in on what matters. Today, we're tackling a really central topic, how companies actually raise the money they need, capital. And just to start, we want to acknowledge that this deep dive is based on documents made available by the University of London. We're using them purely for educational purposes to help you get to grips with these ideas. Also, this deep dive is brought to you by Sinorbit Academy, Sri Lanka. Right. So our mission today, especially if you're starting for an exam on this, is to cut through the noise. We want to highlight the key legal ideas, the definitions, the important laws, and the really crucial court cases so they stick in your mind for exam day. So companies need money. Broadly, how do they actually go about getting it?
Well, you can really boil it down to two main ways.
hmm
First, they can sell ownership stakes. We call that equity capital. So if you invest that way, you become a shareholder, you own a part of the company.
Okay, equity capital, selling shares, getting shareholders. What's the other way?
The other main route is just borrowing money. That's loan capital. And the people or institutions providing these loans, they don't get ownership. They're creditors. The
Yeah.
company owes them money back.
Right. So equity means shareholders and loans mean creditors. That's the core difference we're exploring.
Exactly. And the law regulates both, but how intensely it regulates really varies. It depends on how the money's being raised and who from.
Okay, let's start with equity capital then. Selling shares. When a company does this, who does the law really try to look out for?
Well, there are two main groups that need protection when new shares are issued. First, you've got the existing shareholders.
Existing ones. How does selling new shares affect people who already own some?
Well, it can dilute their stake, their percentage of ownership.
Dilution,
Now,
right?
if you own, say, 10% of the company, and they suddenly issue loads more shares to new people, your 10% isn't worth as much relatively, is it? Your influence shrinks. Unless, of course, you buy some of the new ones too.
Okay, share dilution. That makes sense. So is there a legal protection against that?
Yes, there is. It's called the right of preemption. Very important. It's in Section 561 of the Companies Act 2006.
Piece 561 Companies Act 2006. Preemption. What does it do?
It basically gives existing shareholders the first refusal on new shares, offered in proportion to what they already hold, so they can maintain their percentage if they want to invest more.
So it protects their proportional stake.
Usually, yes. It's often done through what's called a rights issue.
A rights issue.
But it's worth noting, especially for private companies, this right can actually be excluded in their articles, or the shareholders can vote to waive it. So there's flexibility.
Right. And who's the second group the law protects?
That would be the people thinking about buying the new shares, the potential investors.
And the protection for them is quite different depending on whether it's a private or a public company.
Oh, vastly different. There's a really clear legal dividing line here. Section 775 of the Companies Act 2006 specifically stops private companies from offering their shares to the general public.
S775. So, no adverts in the newspaper from Bob's Private Garage Ltd. saying, buy our shares.
Exactly that. Private companies have to raise equity capital from, people they already know, existing shareholders, maybe directors, business contacts, specific private funds, not the public at large.
Why is that restriction there? Is it about protecting the public?
Yes, largely. Private companies don't face the same disclosure requirements as public ones. So offering shares widely to the public, who might not know much about the company, is seen as too risky without those safeguards.
Okay. But public companies can sell shares to the public.
Absolutely. That's often a key reason for being a public company, to raise large amounts of capital from a wide pool of investors. They typically do this by getting their shares listed on a stock exchange, like the London Stock Exchange, the LSE.
And listing offers big advantages for raising capital, presumably.
Huge advantages. You get access to this massive, sophisticated market. It also makes it easier for existing shares to be bought and sold, the secondary market, which investors like. And crucially, it boosts confidence.
Why the confidence boost? Just being listed.
Because to be listed and stay listed, companies have to follow very strict and detailed rules. These are the listing rules. They're enforced by the Financial Conduct Authority, the FCA, which acts as the UK's listing authority.
The FCO. Yeah.
And these listing rules, their whole purpose is to make sure listed companies have a solid track record, and critically, they have to disclose a lot of information so investors can make informed choices.
And the main disclosure document for a big share offer is the prospectus, isn't it?
Yes, the prospectus is key. It's a detailed document about the company, the risks, the finances, the offer itself. It has to be approved by the FCA before the public offer can happen.
Okay, so that's the initial hurdle. Does the regulation stop once they're listed?
Oh no, far from it. There are significant continuing obligations. Listed companies have to publish regular financial reports half-yearly, preliminary annual results, strategic reports. They have to keep the market updated.
And this ongoing disclosure helps prevent things like insider dealing.
Precisely. A really important continuing obligation is to release price-sensitive information to the market quickly. Anything that could reasonably affect the share price needs to be announced promptly. This levels the playing field, stops insiders trading on secret information. If companies don't comply, the FCA can impose sanctions.
So all this disclosure, initial and ongoing, it's all about transparency, helping investors figure out what shares are worth, making the market more efficient.
That's the goal. It helps capital flow to well-run, transparent companies.
Okay, that makes sense for equity. Now, what about the second route? Loan capital, borrowing money.
Right. Borrowing. This is incredibly common, especially for smaller companies, maybe even more common day-to-day than issuing shares.
Where do these loans typically come from?
All sorts of places. Suppliers might offer trade credit, which is a form of short-term loan. Shareholders themselves might lend money to the company, but often it's banks or other financial institutions.
And when it's a bank lending, they often want something extra, don't they? Security.
Yes, exactly. Sophisticated lenders, like banks, will usually demand security for their loan.
What does security actually do for the lender?
It gives them priority if things go wrong. If the company can't repay and gets wound up, a secured creditor gets paid back before unsecured creditors, out of the proceeds from selling the specific asset or assets pledged as security. It's a safety net.
Priority if the company fails. Got it. And the materials highlight two main types of security, fixed charges and floating charges.
That's right. Let's look at a fixed charge first. This is granted over a specific identifiable piece of the company's property. Think its main warehouse or a particular plot of land, maybe a key piece of machinery.
A bit like a mortgage on a house?
Very similar analogy, yes. The charge attaches to that specific asset straight away. And crucially, the company's ability to deal with that asset is restricted. It can't just sell a warehouse or mortgage it again without the lender's okay. Lord Millett, in the Agnew v. Commissioner of Inland Revenue case, described it as giving the charge holder an immediate proprietary interest. The company loses some control over that specific asset.
Okay, so fixed is tied tightly to one specific thing. What about a floating charge then?
A floating charge is different. It doesn't attach to one specific item. Instead, it kind of floats over a class of the company's assets. And this class is usually one that changes over time.
Changes, like what sort of assets?
Things like the company's stock or inventory, which is constantly being bought and sold, or its general machinery and equipment, or very commonly, its book debts, the money owed to the company by its customers.
Book debt. Right, so it covers a shifting pool of assets.
Exactly. And here's the absolute key difference, the defining feature. The company remains free to deal with the assets in that class in the ordinary course of its business. It doesn't need the lender's permission every time it sells some stock or collects a debt and uses the cash.
It can just carry on trading normally with those assets.
Yes, until something happens, like the company getting into financial trouble or defaulting on the loan, which causes the charge to crystallize, then it stops floating and fixes onto whatever assets are in that class at that moment. The classic case that sets out the features of a floating charge is Yorkshire Woolcombers Association back in 1903.
Yorkshire Woolcombers Association, 1903. What did it say?
Well, Rummer LJ in that case identified three key characteristics. First, it's a charge on a class of assets, present and future.
A class of assets.
Second, that class is one which, in the ordinary course of business, would be changing from time to time.
Changing assets?
And third, and this is the clincher, it's understood that the company can continue to carry on its business and deal with those assets, sell them, use them until the lender steps in. That freedom to deal is key.
That freedom to deal seems absolutely central then. It's not just about the label floating charge.
Not at all. Courts look at the substance. Does the company still control and deal with the assets day to day? If yes, it points strongly towards a floating charge, whatever the document calls it.
So comparing the two from the lender's point of view, especially if the company goes bust, how do they stack up? Is fixed better?
Oh, definitely. A fixed charge gives much better security in insolvency. If the specific asset under the fixed charge is sold, the fixed charge holder gets first claim on all the money raised from selling that asset until their debt is fully repaid.
They get paid first from their specific asset.
Yes. Floating charges rank lower in the priority list.
Lower. Who gets paid before the floating charge holder then?
Well, first, the costs of the winding up process itself, the liquidator's fees and expenses. Then, certain preferential creditors,
Preferential creditors, like who?
employees for certain amounts of unpaid wages and holiday pay, for example.
Okay, costs and preferential creditors first.
And then there's another big one. Under Section 176A of the Insolvency Act 1986, a portion of the money realized from assets covered by a floating charge must be ring-fenced for unsecured creditors. It's called the prescribed part.
S176A Insolvency Act, 1986. The prescribed part for unsecured creditors. Wow, so even after costs and preferential creditors, the floating charge holder doesn't get everything. Some goes to people with no security at all.
That's right. It carves out a fund, sometimes called the prescribed part, to give unsecured creditors at least a small return when often they'd get nothing. It definitely reduces what the floating charge holder recovers.
So that's a clear disadvantage for the lender holding a floating charge. Are there others?
Yes, another significant one is that floating charges can sometimes be challenged and declared invalid or avoided if they were created too close to the company becoming insolvent. This is under Section 245 of the Insolvency Act 1986.
S245 Insolvency Act, 1986. Avoidance. Why would the law do that?
It's designed to stop unfairness. Imagine an unsecured creditor, seeing the company struggling, quickly takes a floating charge over all the assets just before the company collapses. Section 245 tries to prevent that last-minute grab that prejudices other unsecured creditors. The rule basically says a floating charge created within 12 months before the onset of insolvency, that's the relevant time, might be invalid.
12 months, okay. So taking a floating charge for an existing debt within that year is risky for the lender.
Potentially very risky, yes. It might be invalidated. Now, there are exceptions. It generally won't be invalidated if the charge was given for new money cash provided to the company at the same time or after the charge was created, or if the company was actually solvent immediately after creating the charge. That's under S.245, subsection 4.
Ah, so new money is okay. Or if the company was solvent.
Yes, but be careful with connected persons, like directors or their families. If the floating charge is granted to someone connected to the company, the relevant time is extended to 2 years, not 12 months. And that solvency exception in S2454 doesn't apply to them.
2 years for connected people and no solvency defense. The law is clearly much more suspicious of those deals.
It is, yes. Understandably so.
Okay, so we've established the label isn't decisive, the substance matters, especially that freedom to deal. What's the really key case that clarified this distinction?
The big one, the modern authority, particularly on that crucial point about the company's control over the assets, is National Westminster Bank, PLH v. Spectrum Plus Ltd. from 2005, a House of Lords decision.
National Westminster Bank PLH v. Spectrum Plus Ltd. 2005. Got it. What did it say?
Lord Phillips put it very clearly. He said the hallmark of the floating charge was the agreement that the charger of the company should be free to dispose of his assets in the normal course of business unless and until the charge the lender intervened. That freedom is the key identifier.
That phrase, free to dispose of assets in the normal course of business, really sums it up.
It does.
Now, the source material really drills down on one specific type of asset where this fixed versus floating debate became critical: book debts.
Ah, yes, book debts, money owed to the company by its customers. They're often a very significant asset, especially for service businesses or manufacturers selling on credit.
So companies want to borrow against them. What's the difficulty?
The difficulty is exactly that freedom to deal. A bank might take a charge over book debts and label it fixed, but the company needs to collect those debts and use the cash coming in to pay wages, suppliers, keep the lights on.
So even if the paperwork says fixed, if the company collects the money and just uses it freely in its bank account, it looks a lot like it still has control, doesn't it?
Precisely. And this was the exact issue in the Spectrum Plus case. National Westminster Bank, Paloki v. Spectrum Plus Ltd. 2005 was all about a charge over book debts.
Okay, Spectrum Plus and book debts. What were the facts there?
NatWest had a charge over Spectrum's book debts. The charge document called it a specific charge, meaning fixed. It required Spectrum to pay all the money collected from debtors into an account with NatWest.
Sounds potentially like control for the bank?
You'd think so. But the crucial bit was that Spectrum was allowed to draw money out of that account for its business needs, as long as it stayed within its overdraft limit. There were no restrictions on withdrawals beyond the overdraft.
Ah, so the money went in, but Spectrum could pull it straight back out again to use.
Exactly. And the House of Lords looked at the reality, the substance. They said because Spectrum could draw freely on the account, it still had control over the proceeds of the debts. Therefore, despite the label, it was a floating charge.
Yelled it was a floating charge because of that ability to deal with the cash once collected.
Yes. Lord Scott particularly emphasized that the bank didn't have sufficient control over the proceeds of the debts once they hit the account. Spectrum could use them just like any other cash.
So what would a lender, like a bank, actually need to do to make a charge over book debts genuinely fixed?
They need to exert much more control over the collected money. The proceeds must be paid into a dedicated account, often called a blocked account.
A blocked account. What does that mean in practice?
It means the company cannot draw funds from that account freely. Withdrawals would need the bank's specific consent. The bank effectively controls the release of the funds.
Right, so the money is trapped until the bank agrees to let it out. That does restrict the company's ability to deal with it.
It does. But you can see the practical problem. Most companies need access to the cash collected from their customers to run their business day to day. Agreeing to a fully blocked account is often commercially difficult.
So the result of Spectrum Plus is that most charges over book debts, in reality, are likely to be floating charges.
That's the practical consequence, yes. Unless there's a properly operated blocked account, which is relatively rare, a charge over book debts will almost certainly be deemed floating. Which means, in an insolvency, the bank won't get first dibs on all the collected debts. The proceeds will be subject to those prior claims, winding up costs, preferential creditors, and that S.176A prescribed part for the unsecured creditors.
Okay. Are there any cases where a fixed charge over book debts has worked?
Yes, it's not impossible, just difficult. The case of ReHarmony Care Homes Ltd. 2009 is sometimes cited as an example where the specific controls in place were considered strict enough to create a fixed charge even after Spectrum Plus. But it reinforces that the level of control has to be very high.
ReHarmony Care Homes Ltd. 2009, showing it can be done, but it's tough.
Right. This makes the distinction much clearer. Okay, we've covered a lot of ground: equity, loans, fixed and floating charges, key cases. Let's pull this together for exam preparation. What are the absolute must-knows from all this? Well, thinking strategically for an exam, you need a clear grasp of the main concepts and the legal framework. The source advice is good here. First, nail the difference between equity capital and loan capital. Shareholders versus creditors.
Equity versus loan capital. Check.
Understand how raising capital links to other big company law ideas. Limited liability is key. It makes equity investment attractive, but it also makes security more important for lenders.
Okay, link to limited liability.
For equity, know the two protection angles. Protecting existing shareholders, think preemption rights, S.561, and protecting buyers.
S561, preemption. Got it.
For buyers, the big split. Public companies can go to the public market. Private companies are restricted by S.775.
This 575 restricting private companies, yes.
For public companies, you don't need every detail, but know the outline of the regulation. Listing rules, the FCA, the prospectus, continuing obligations for disclosure. Understand the purpose-building trust for public investment.
Okay, public company regulation overview.
Then, loan capital and security. Know the two main types. Fixed charges versus floating charges.
Fixed versus floating charges. Crucial.
Remember, floating charges are unique to companies and LLPs, but they have significant drawbacks for lenders compared to fixed charges. The absolute core point is the difference. Companies control an ability to deal with the asset. That's the Spectrum Plus test.
Spectrum Plus test control.
Know how that applies specifically to book debts. Remember, Spectrum Plus decided they're usually floating unless the cash goes into a genuine blocked account.
Book debts, Spectrum Plus, blocked account, right.
Know the priority rules for floating charges. They rank behind costs, preferential creditors, and critically, part of the proceeds goes to unsecured creditors via the S.176A prescribed part.
Priority, S.176A prescribed part.
And be aware that floating charges can be avoided under S.245 if created too close to insolvency, especially for connected persons.
S245 avoidance.
Yeah. And maybe just mention, as a practical point for smaller companies, personal guarantees are often used, where directors essentially bypass limited liability for that specific debt.
That's a fantastic summary for revision. So grasp the concepts, know the rules, purpose, remember the key sections S.561, S.775, S.176A, S.245, and the landmark cases, especially Yorkshire Woolcombers Association and National Westminster Bank PLC v. Spectrum Plus Ltd.
Exactly. Yorkshire Woolcombers Association, National Westminster Bank PLC v. Spectrum Plus Ltd. Get those clear in your mind. And perhaps a final thought to reflect on, using that sample exam question. One of the great advantages of running a business through a company is that it is much easier to raise substantial amounts of capital. Discuss. Think about how everything we've covered feeds into that. Limited liability for equity, yes. Public markets for large sums, yes, but heavily regulated. Floating charges as a unique tool, yes, but with drawbacks. Is it always easier? Maybe not for a small startup needing a bank loan without assets. It requires a nuanced answer.
That really ties it all together. A great point for reflection. Thank you so much for walking us through all of that. And our sincere thanks again go to the University of London for providing the source materials that made this deep dive possible. And remember, this deep dive was brought to you by Sinorbit Academy, Sri Lanka.
And to everyone listening, especially those facing exams, the very best of luck. We hope this discussion has helped clarify things.
Absolutely. Good luck. Keep exploring, keep learning, and join us next time for another deep dive.